members are invited to return to their seats. I ask the greffier to open the vote.
So,
All members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce the proposition has been adopted. 31 votes pour, 8 votes contre, and 6 abstentions. Accordingly, Deputy Ozouf is suspended until sentenced by the Royal Court.
May we have the names, please, sir?
Yes.
Those voting pour, the Connotabs of St Lawrence, St Brelard, St Peter, St Martin, St John, St Clement, Rouville, St Juan, St Mary, Deputies Southern, Tadier, Doublé, the Hegara, Ayer, Rob Ward, Alves, Gardner, Farnham, Mezek, Coles, Porray, Miles, Renouf, Catherine Curtis, Faltham, Jearn, Miller, Ferry, Kovac, Alex Curtis and Barbara Ward. Those voting contre, the Connotabs of St Helier and St Saviour, Deputies Labby, Moore, Balash, Rose Binet, Howell and online Deputy Binet, Tom Binet, and those abstaining, the Connotab of Trinity, Deputy Ozouf, Deputies War and Scott, Wilson and Andrews.
The next item is the draft Harbours Inshore Safety Jersey Amendment Regulations, lodged by the Minister for Sustainable Economic Development. The main respondent is the Economic and International Affairs Scrutiny Panel. I ask the greffier to read the citation.
Draft Harbours Inshore Safety Jersey Amendment Regulations 2000. The states make these regulations under Article 4 of the Harbours Administration Jersey Law 1961 and Article 49 of the Shipping Jersey Law 2002.
The debate resumes following the adoption of the principles on the 8th of July and the referral of the matter to scrutiny. So we're now in the second reading. Minister, how do you propose the regulations?
Sir, I en bloc.
Do you wish to address the regulations?
Sir, yes, sir.
Right.
Thank you.
Yes.
Sir, I'm pleased that the scrutiny panel has conducted their review and concluded their review with no amendments to the draft regulations, and with the endorsement that the proposition represents an important step towards enhancing sea safety. The review resulted in several findings and recommendations, which I've addressed in an addendum to the lodging report. Sir, the objective of this proposition is to make Jersey's territorial waters safer for all, strengthening our maritime legal framework and increasing user accountability. The proposition introduces new offences for dangerous and careless operation of a vessel, including where serious injury or death has occurred, and aggravated offences for when alcohol or drugs are involved. The proposition also grants the Police and Harbour Master new powers to breathalyse vessel operators based on reasonable suspicion of careless operation or serious harm. This expands the current law, which only permits stopping a vessel for reckless operation, but does not mandate testing. No standalone offence for operating a vessel whilst under the influence. However, to ensure those who use our waters are doing so safely, I'm introducing an offence for careless operation whilst under the influence. This offence will allow for breath testing based on suspicion of careless behaviour, without the evidence of or suspicion of injury or fatality. The aim is to avoid penalising responsible operators. There is no evidence of a consistent problem of people dangerously operating vessels whilst under the influence. Thus, I'm not introducing random breath tests, making the offences proportionate to the level of risk. And I think it is appropriate to say here that rather, enforcement will be based on reasonable grounds for testing. This approach mirrors that of other jurisdictions, including the UK and Guernsey, where random testing does not occur. This is also consistent with the road traffic law, where police officers cannot randomly breath test drivers without reasonable suspicion or lawful cause. To support joined-up working between Ports of Jersey and States of Jersey Police during the course of maritime investigations, the two parties have agreed and signed an enforcement memorandum of understanding. What I am proposing, sir, is a measured approach. While our waters are not currently deemed unsafe, P3 will provide clarity on acceptable and unacceptable conduct, providing greater accountability for all sea users, helping to prevent incidents before they occur. Sir, I urge States members to adopt the proposition. There is an enforcement case which occurred in the summer where the involvement of alcohol was strongly suspected by Ports of Jersey, but they were powerless to breathalyse. This proposition could have enabled that if it had been adopted. Sir, this proposition represents an important step in strengthening our maritime law, ensuring it is fit for purpose in protecting all who enjoy our waters and establishing clearer duties and legal responsibilities, and ensuring proportionate charges can be levied against those who behave improperly. So, sir, I ask States members to support the regulations. Thank you, sir.
Thank you, Minister. Are the regulations seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the regulations? Yes, Deputy Tadio.
Thanks, sir. So I'm speaking to the regulations as a whole, really, so there may be some that I'll focus on more rather than others in my comments. And as the Minister's obviously moved the comments on block, I presume that's okay to do in terms of process.
Yes.
So, of course, only speaking once, and I think we'll decide whether we want to ask for any particular articles to be taken separately, sir.
Yes.
So, first of all, can I thank for the Assembly for their, I'm going to say indulgence, it didn't really have any choice in this because it was called in, but for their patience, but also thanks for the Minister and, of course, the stakeholders that were involved as we, I think quite rightly, did call this in for scrutiny. And just to remind Assembly members as to why we did that, we really had two main areas of concern. One was that we wanted to, first of all, understand the Memorandum of Understanding between the States of Jersey Police and the Ports of Jersey, not just to understand the MOU, but also to understand what that meant for the working relationship in reality as it will be from now on between the two. And of course, we have to point out the fact that had we passed these articles at the original debate before the summer recess, we would have been doing it at a time when the MOU hadn't been finalised and when it hadn't been signed. And we certainly had concerns about some of the content in that. If I'm honest, and the comments reflect that, we have issued, of course, by now 3 lots of comments papers. So an initial comments paper when the principles were debated in July. We issued a second comments paper early last week, and then we did go back to the for a third. We put a third comments paper after we've had some further interaction with the Minister. So, following the deferral of the debate, the panel does remain concerned both around the clarity and the content of the Memorandum of Understanding between the States of Jersey Police and Ports of Jersey. In our comments paper on the 17th of October, sir, the panel made 7 findings and 8 recommendations, highlighting in particular the lack of clarity surrounding the enforcement of the draft regulations set out in the MOU. The Minister for Sustainable Economic Development did respond to us on the 20th of October. As I speak, I realise I probably got my chronology slightly wrong, of course. So this was the paper that we issued, the second paper in October, and then the final paper last week. So the Minister included responses to the panel which were published and that we've put in our annex in our final comments paper. The panel welcomed the publication of the MOU, but as I've said, the panel notes, we note that there are earlier key findings and recommendations which we don't think have been reflected in the updated version. So, for example, on the 24th of October, we wrote to the Minister to highlight our ongoing concerns about elements in the MOU. The panel reiterated our recommendations based on the report around we did engage an expert advisor, sir, and particularly around the inclusion of dispute resolution mechanisms and financial arrangements. Following the Minister's response, we remain concerned that the absence of clearly defined roles and responsibilities amongst the agencies tasked with enforcing the draft regulations, as well as the omission of essential information as highlighted in the experts advisor report. So why is this important? Well, I think there are two ways to look at an MOU. One is that it's a fairly informal, flexible document which can be slightly light on detail as to what is expected by both parties. I don't want to be putting words into the mouth of the Minister, but we feel that's perhaps the direction that the Minister was explaining the current MOU. Well, that's our assessment of it, whereas our view and that of our advisor is that there really are key things that you would expect to see in an MOU, and that the more wiggle room, if you like, wiggle room can be seen as a good thing, but if it means that in future there is uncertainty about who is responsible for what in terms of delegation of responsibilities, who investigates what, then it becomes probably possible that we're storing up problems for that relationship in the future. Why is this important? It's because we're introducing effectively new criminal, criminal responsibility for potential matters that would take place in harbours and offshore in Jersey waters. And it really is therefore important about knowing who is going to do what in any given situation. And there are still things in the ports, in the MOU between ports and States of Jersey Police, and I'll give an example. In paragraph 4 of the MOU, it says that ports of Jersey may, and we've underlined may and put it in bold, refer incidents of this nature to the States of Jersey Police. The ultimate decision will be made by the States of Jersey Police as to which organisation will take primacy and who will lead the agency in the investigation. So we ask, can you please clarify, Minister, under what circumstances ports of Jersey may refer incidents to the States of Jersey Police? And the answer was that ports of Jersey may refer any incidents that exceed its investigative capacity or involve suspected serious criminality, including when serious injury occurs, and that if ports of Jersey may refer incidents to the States of Jersey Police, we've asked, can you clarify how the ultimate decision will be made on who will take primacy for that? So there is almost a chicken and egg going on here in terms of decisions really not being put down in black and white as to who will investigate what. But one example is, for example, if a death takes place at sea, and it remains to be seen whether that death involves any criminality. So was that death as a result of some negligence of somebody on board? Was the death a result of something which may end up being the equivalent of manslaughter, or that may involve one of the new charges, which is death by dangerous operation of a vessel or death by careless operation of a vessel. And of course, until you know whether or not those criminal charges have actually, that criminality has taken place, it's still to be determined. Who is going to be first at the scene in any of those situations? It's very likely that it's going to be a Ports of Jersey, a harbour master type of person rather than States of Jersey Police, simply because States of Jersey Police don't have boats. So it is going to be, of course, the Ports of Jersey who are going to be first on the scene. And I think we still have concerns about, notwithstanding some of the reassurances that we've been given, around things like collection of evidence. So I think it's called PACE, is that correct? about the collection of criminal evidence. If at the scene, at the arrival of the scene of a crime, how do we know, for example, that ports of Jersey are going to have the wherewithal and the sufficient training to actually determine, first of all, whether there is any criminality that needs to be looked at, and at what point do they get the States of Jersey police involved in that. So we have issued comments. I know that we're all human. I mean, we've learned that, haven't we? And I don't expect everyone to have forensically read necessarily any or all of the comments papers, but I do emphasise the fact that these are there for members to look at. And certainly, we wouldn't have felt comfortable passing what was put to us before July without having looked at this. I would say that we're slightly more comfortable passing this, but I'm not sure that certainly when it comes to the MOU, that there is still enough detail in there. And certainly, on one level, I would be saying to the Minister, we accept, I think, your point of view that the MOU is that the Minister's point that the MOU is very much a living, working document. It's something which will constantly need to be reviewed, as we hope that, of course, a lot of the offences which are referred to and created in this new legislation, in these new regulations, do not need to be ever used. But of course, that's a blue sky, maybe a blue water kind of world that we're thinking about. We know the reality is that there have been gaps in the law, and this legislation in itself is both necessary and will hopefully be useful. But we hope it will be used in rare occasions, sir. The next point I think we have to get onto here, because I think it does need at least some modicum of debate, is what I can only call is the contradictory position that we may be sending out, the contradictory message when it comes to the consumption of alcohol, and I would say to a lesser extent the consumption of drugs, although it could easily be drugs when in charge of a vessel. And it becomes a slightly circular problem in a sense. So first of all, we have to remind ourselves that P3 is also seen in the context of P4, which we passed earlier in the year, sir. So the definition of what a vessel is very broad. It can be anything from a kayak to a surfboard, a paddleboard, to a jet ski, to a speedboat, to a sailboat, or to a very large vessel, and anything in between. And that can both be a good thing and a bad thing. It's broad, but it also means that it very much relies on sensible policing when it comes to how one applies both the public interest and maybe the evidential tests in what constitutes perhaps the dangerous or careless operation of that vessel. Clearly, somebody going out on a paddleboard or on a kayak when they might have had a couple of beers, the damage they're likely to do is completely different to somebody who might be in charge of a large powerboat who is still in inshore waters in terms of who they're likely to injure. The message, I think, has to be from whether it's scrutiny or the Minister, do take care when you're on the water, and it's always preferable not to drink and to be in full control of your body, but also in control of the vessel that you're commanding, sir. But that's not what the law says. The law, unlike the road traffic law, says that it's perfectly okay to get behind the wheel of a boat if you've had lots to drink. There's no legal impediment to doing that, which is completely different, of course, to what we would expect nowadays in a car. In fact, it's a long-standing practice that you don't drink and drive, and drink and drive limits have only ever come down. The problem we've got within the law and in some of these cases is that it becomes an aggravated offence if you have drunk. And so, of course, drinking in itself is not wrong in the eyes of the law. If you're going onto a boat, you can do that. You can do that only if you can still maintain the ability to drive, can I say, without being careless or without being dangerous, and certainly without injuring somebody or in the worst case scenario, killing somebody. So the answers we got back from the Minister when we questioned the logic of this was very much, well, the point is you can be drunk and be perfectly able to steer a boat, and you can go out on a long journey and come back in and do that very safely. You don't commit an offence, but you can be completely sober and, of course, still commit an offence if you're steering that boat carelessly or dangerously. So the two are not inherently linked. Where it does become a problem is if you commit an offence and you have been drinking, or you have been taking drugs and you're over the limit that you would be in a car, then that becomes an aggravated offence where you would attract a higher penalty. It takes something for me to get my head around that, as to say, if we're using the road traffic law as the starting point for introducing these new regulations and these new criminal acts, why don't we just simply copy and paste what is in the road traffic law and say, for clarity, if you wouldn't have 2 pints of lager and get in the car, if you wouldn't drink half a bottle of wine and get in the car, then you shouldn't also be getting behind the wheel of a boat or the helm of a boat. And the arguments, of course, come back about proportionality, saying the sea is a very different place to the roads. There aren't as many vehicles in the sea. You've got vast open spaces. There's also a cultural difference in the way that drink sometimes goes in hand, and you might use your yacht, shall we say, for leisure purposes as well as just for transportation purposes, and all those things are true. So we accept that there has to be a level of proportionality in that. But it seems to me that if the minister were minded to, none of these things would be insurmountable. So, for example, you could make it quite clear that you wouldn't be committing an offence if you were moored up in your boat, either close in or further out to sea, and you were sleeping for the night, and you'd had a few drinks and you were sleeping it off, and you waited till the morning until you were sober and then left. Nobody's going to come and knock on your door or your window in the middle of the night to breathalyse you in your sleep, because first of all, there'd be no public interest in that, but it also could be phrased so that it wasn't an offence to simply be drunk on board of a vessel. You'd actually have to be in charge of a vessel. So I leave it to members to consider whether they think, A, that the new criminal acts that are being proposed are sufficient and that they go far enough, and actually whether it becomes problematic to say to somebody who has an accident at sea, and I think this is the very real scenario about why I think there's a strong argument to say we should legislate at some point in the future in the same way we would do for vessels. And I'll give members a scenario. So somebody is driving their car from Gorey to, should we say, to St Clement's Parish Hall, and they're using the coast road, and at some point they hit somebody and they kill somebody. So a very serious incident takes place. Now, for that person has also been found to have been drinking, and it also transpires that the person that they've hit, actually, they couldn't have done anything to avoid them, whether they were sober or drunk. So in fact, this person has put themselves in the middle of the road, they've literally jumped out, they didn't see the car didn't see them, and they had no choice but to hit them, and that person died. The person wasn't speeding, they were doing maybe 35 miles an hour. That person went to the hospital and died. That the person who's been drink driving there will be guilty irrespective of whether or not they were technically in the wrong. They can't plead to the court saying, well, actually, that person jumped out on me. There might be some mitigation in that, but you've been a drink driving, death by dangerous driving, whilst you're under the influence of alcohol, is a standalone offence, as it would be in a boat. But of course, if you're driving along and you kill someone and you haven't been drinking, and you can prove that it was a genuine accident, there'll be no consequence for you. But the scenario on the other way around is that if you're on a road and you drink and you don't hit anybody and you get home in one piece because you're an excellent driver, like in Rain Man, I think, I'm an excellent driver, you've committed an offence nonetheless, because you could have hit someone on the way back. You were taking an unnecessary risk, and it doesn't matter whether you're the best driver in the world, you're a couple of units over the limit, you will feel the full force of the law if you get stopped and breathalyzed. But if that happens on a boat, fill your boots. So that's the message that the Minister, I think, is sending out today in passing this legislation. This is not something that we as a panel were entirely comfortable with. I don't think, because we're evidence-based as a panel, we don't have the full evidence that we've received in terms of our feedback from the public on this matter. Most of the submissions, admittedly, did come from the boating fraternity, who very much, I think, came up with reasonable arguments that I made at the beginning about proportionality, about not comparing like for like when it comes to road and the sea. And I think simply it would have been remiss of us as a panel to have proposed any alternative to that, notwithstanding, of course, the fact that also it's not necessarily the job of scrutiny to propose alternative policy. It is for us to scrutinise the policy of the Minister. So what we would say to the Minister, and I think there has been a little bit of a rapprochement, hopefully, over the course of the review. I like to think I've certainly can see the other side, even if I may still hold some views that says let's do it in a certain way perhaps in the future. We would say to the Minister very strongly, let's keep this under review. I think he's given an assurance that certainly the MOU and the rolling out of the law will be kept under review. I think there's a 2-year period in which the MOU will periodically get reviewed. We as a panel are, I think, relatively relaxed, not relaxed, maybe the wrong word. We're relatively comfortable that we've probably done a large amount of scrutiny, necessary scrutiny on this, and that we think that some of these matters will be referred to in future. In summing up, sir, in closing my remarks, I would say, of course, that there are different ways to do things. So whilst we don't make alternative policy, we're always mindful of other jurisdictions, how they do things, and counterfactuals, things that could be done that are not currently being done. And one would point out that certainly Bermuda is a very interesting example. I think I'm right in saying that they've quite recently, in the last 10 or 15 years, introduced quite holistic legislation around their maritime sector, which does include, of course, the fact that you can't drink and be in charge of a vessel, but there's also very proactive policing that goes on. So what I do know is that from our review is that there is already some very good information that's put out there by Ports of Jersey in terms of case studies that have been done about how safety at sea. If you didn't know where to look for them, you might not know, but we would hope that those in the boating community are aware of them. And we would urge also that the Minister engages in an education programme, sir, because actually, whether it comes to safety on the road or safety at sea, these things really need to go in hand with both education. We know there's a different starting point when it comes to boats. As many told us during the review, the difference between a car and a boat is that you don't need a licence to have a boat. You just need the money. If you can go out there and buy yourself a big yacht or a big power boat, sir, and you can dock it and you have insurance, then you're free to go. And that certainly wouldn't happen with a Ferrari or a Porsche, sir, but it does happen when you're at sea. So it's therefore even more important that there is the culture of safety when it comes to sea, sir. So I leave the comments there. There's no doubt things that I've missed. I would like to thank the panel members for their support in this review, which seems to have gone on for a long time, but thank also our advisor, who I thought brought some clarity as an external person, which we may have lacked because sometimes you can get too close to the subject material, sir. So again, I'll leave my comments there.
Thank you, Deputy. Does anyone else wish to speak in second reading? Conatap St Brelard.
Thank you, sir, and I thank the chairman of the panel for the panel's comments. I would just like to question the definitions that the deputy refers to. I see the definitions as being very difficult to apply, and in my experience of, I don't know, some 60-odd years boating, I found, observed, I suppose I should use the word, that incompetence and negligence is not always the same thing. And someone might buy a sailing boat with a full, lots of enthusiasm of sailing it, but that actually they will never be able to, and they are at the behest of the weather. So I think any definition with regard to boating is of necessity broad and grey. And I think, on balance, that the proposals from the Minister are probably as close as can be got to put some sort of framework around the law as proposed. Thank you, sir.
Thank you, Conatap. Does anyone else wish to speak in second reading. Deputy Scott.
So I heard with interest the panel's deliberations on this subject and note that they accept there's a different culture in terms of the sea, as it were, and a whole different kind of landscape. I just noted that with the comments, at least their second comments, a large amount was redacted, and so I think maybe they could, at least the version that I've got, having looked through it, so maybe they might look at that. But also that the idea that there should be a kind of parity between road offences and sea offences, that it could be just taken further and further, if you like, and perhaps not resolved, that you need a driving licence of a car, not for a boat, and that doesn't seem to have been explored. So I do accept, though, and I think everybody needs to accept there could be more work to be done in terms of MOUs and these elements. I just regret that a summer has passed and these regulations weren't in place for the last summer season, and I'm glad that nothing similar to the accident that prompted them has happened.
Thank you, Deputy. Harbours St Mary.
Thank you, sir. I rise very briefly to thank Deputy Taddy for his comments, particularly in relation to MOUs being a living document. The Treasury Minister, I'm sure, will attest to the fact that she's regularly questioned about the current MOUs. My political career began with my being on the Economic Affairs Scrutiny Panel, whose first job was to scrutinise the incorporation of Ports of Jersey. And we went into the MOU with some gusto at that stage, and we have since been back on that. And I view, and I'm sure most panels view, the MOUs as very much a living document, and I take it that the Economics panel will, in their legacy report, highlight this particular matter. As something aside, sir, I wonder if, in considering future enforcement, the Minister will accept that it would be a very good recruiting exercise if police launches could be made available to each of the parishes to enable them to enforce the driving aspect, sorry, not driving aspect, the drunken charge aspect, but perhaps that should be left to the next budget. Thanks, sir.
Thank you, Ozouf. Does anyone else wish to speak on the regulations in second reading? I call upon the Minister to reply. Minister.
Thank you, sir, and I thank the chair of the panel and his panel members for their hard work in undertaking this review and for their comments. I really do appreciate them. So I will start with the last comment first, because I have visions of the Conatable of Grouville launching from Gorey to go on the high seas with his police launch, the parish launch. Certainly something for the next assembly, perhaps. So I think it is really important to understand the separation between the Memorandum of Understanding and the actual regulations we're voting on. I think the panel's work on the Memorandum of Understanding is helpful, and I am grateful for it. But we are not voting on the Memorandum of Understanding. The Memorandum of Understanding between Ports of Jersey and the States of Jersey Police is a document to help those two organisations navigate their own relationship. And it is, as Deputy Tadia said, it is a document that will be a living document. It will be reviewed by them on a regular basis. And it is entirely appropriate, as the Constable of St Mary has just said, that the scrutiny panel and future iterations of the scrutiny panel keep it under review as well. But from our perspective, it is very important for this Assembly to understand that we are not voting on the Memorandum of Understanding. And that document represents the wishes of the Chief of the States of Jersey Police and the Harbour Master as to how they wish to navigate their own relationship between their two organisations. And as such, I think it's important that we do, whilst maintaining an eye on it, we do accept that it is not our place to determine their relationship and how they work together. It is right that they do that themselves. And they have started that with this Memorandum of Understanding. As them being happy with it is the most important factor. I think, sir, it is worth me talking about a little bit about my views in terms of proportionality. So the kind of birth of this law, or the inspiration, so to speak, if that can be the correct word, for this law came from noticing several holes, most notably one large hole in the current regulations, which basically mean it is not possible to oblige any boat owner, boat user, boat operator, I should say, to undertake a breath test or any other test to determine whether they have alcohol or drugs. That's the situation we are in today. There is no way of obliging that testing. So the principal aim from setting out these regulations on those parts of the regulations was about bringing in the ability to oblige breath testing and to do so in a proportionate manner. And the proportionate part comes from because it is truly my belief, and I think it should always be the view of the Assembly, that we legislate proportionally. We do not legislate to the extremes, and we do not legislate in a way that doesn't take the island's population with us. Because ultimately, every law we put in place, whether it's in financial services or boating or anywhere else, impacts a freedom somewhere. It is guaranteed to be taking something from somebody somewhere. So we need to know that we are taking it that freedom in a proportional way. And I believe these regulations do exactly do that. And part of the reason is, and I think the Council of St. Brelard said this very well, is that definitions are more difficult on the sea. What fits the road the road has a far, far higher density of users than the sea does. I mean, far higher. Almost impossible to calculate how much higher the density of people is on the road compared to the density of people on the sea. And I think the idea of being drunk in charge of a vehicle on land is very different to being drunk in charge of a vehicle on the sea. And the chair of the scrutiny panel did refer to that idea of falling asleep. Many people they arrive in Jersey from elsewhere. That's their hotel room for the night as much as it is their transport home. And so obviously they can go out, and drink a merry amount, and then have to go back to that vessel, and they are then in charge of that vessel, but that's their hotel room for the night. I agree, it could be worked around, but it would complicate things, certainly. And equally, though, sadly, not everyone is sober when they wake up in the morning. And I know the State's Jersey Police sometimes do patrol in morning times because they are concerned that people can have been drinking the night before, had a few hours sleep and jump back in their cars. But the impact on boat owners, I think, would be very different and would perhaps be unnecessary. I think as well there is a reality around enforcement of such a kind of very clear, very defined roles around whether you are drunk in charge or not. I think there would be enforcement problems around that. I completely agree with Deputy Tadia about education. It is really incumbent on both the government and Ports of Jersey to ensure that education is provided to all boat owners. I think it is an area that we need to constantly engage with, and I know Ports of Jersey do, and I will work with them to ensure that we continue that level of education to make people understand there is a new regime if these regulations are passed, but also that regardless of whatever legal regimes are in place, they should always be operating their boat safely. I mean, my view is, if you are operating a boat, it is better, and you should, it is always preferable not to have been drinking or taking drugs before operating a boat. But I do know that, particularly when it comes to having a drink, people do entertain on a boat and such like. So the message is always operate your vessel safely. And if you have been drinking, please, it is preferable not to go and take your boat. I think these regulations, though, do give powers to the harbour master, which means the harbour master can now enforce in a way that he couldn't previously. I think that's the most important thing. It is important, as Deputy Scott mentioned, that we do not let another summer go where it is not possible for the harbour master to oblige someone to take a breath test. I think that we mustn't do that for another summer. We can strengthen these, and this is always my view. if we do need to move in the future to a situation where the sea is viewed as the road, we as an assembly can do that. These regulations don't stop that happening. This is just a different step. It's not even a smaller step. It's just a different step that I believe is more appropriate for the seas and for boat users. So, sir, with that in mind, I do ask the Assembly to support these regulations. I think they do give powers to the Harbour Master and the States of Jersey Police that are currently not there on the statute book and are needed on the statute book. And I do ask all members of the Assembly and the scrutiny panel, do please keep reviewing. You know, I am not saying this is the end of the journey. I'm saying this is the next step on the journey. So I ask members to support the regulations. Thank you, sir.
So would the Minister clarify a point? Could the Minister clarify that when he says that to give the Harbour Master powers to insist on a breath test, that's only in a scenario where another offence has been committed, so dangerous or careless operation of a vessel, and so when they suspect that offence has been committed and when they suspect that the person has been drinking. It's not just a licence to go around breathalyzing ordinary, otherwise law-abiding users of the sea.
So that is correct. I said so, at least I believe, in my opening address. And that is similar to the road traffic law. It is not possible to just randomly breath test road users. There has to be cause. There has to be a reason for a police officer to suspect. And this is very similar to that. If the Harbour Master or his officers have reason to suspect that somebody has been operating a boat carelessly or dangerously, then they have the ability with these regulations to ask for a breath test. I feel there may be another question.
I was just going to ask, so can the Minister clarify it's not the same as the road, because a police officer can just insist on a breath test if he thinks or she thinks somebody's been drinking, because that is the offence. But that doesn't exist, of course, when it comes to these regulations.
There's a slight nuance, sir, I agree. The police officer who has reason to believe, perhaps they've seen somebody drinking for a few hours and then gets in their car, they can go then. In this case, it is about the actual conduct of the vessel. There needs to be the suspicion of careless or dangerous operation of a vessel. But in my view, and I believe in the view of others, that is an appropriate step in this case, sir, because again, it is difficult necessarily to know whether someone has been drinking before they got on a vessel or not. They could have been on that vessel drinking. Thank you, sir.
Is the appel called for?
Yes, sir. Yes, sir.
And you're asking members to consider regulations 1 to 5 inclusive, yes, Minister?
Yes, sir.
Members are asked to return to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the regulations have been adopted in second reading. 43 votes for and 1 vote contre.
Deputy Southern voted contre.
We now move to the third reading. Do you propose the matter in third reading, Minister?
So I do, yes.
Are the regulations seconded in third reading? Does any member speak on the matter in third reading? Thank you. All those in favour of Deputy Morell? No, we don't want to speak because you can only reply. All those in favour kindly show. Thank you very much. The regulations are adopted in third reading. The next item is the draft regulation of care amendment law lodged by the Minister of the Environment. The main respondent is the Chair of the Health and Social Security Regulation of Care Scrutiny Subpanel. I ask the greffier to read the citation.
Draft Regulation of Care Jersey Amendment Law 2000, a law to amend the Regulation of Care Jersey Law 2014, the Regulation of Care Standards and Requirements Jersey Regulations 2018, and the Public Finances Jersey Law 2019, and for related purposes. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. Sir, this draft Regulation of Care Amendment Law represents a significant and necessary step in the continued development of Jersey's framework for the independent regulation of health and social care services. It extends the scope of the Regulation of Care Law, enabling the Jersey Care Commission to regulate additional services, specifically hospital care, government-provided mental health services and ambulance services. These are critical components of our health system, and it's right that they be subject to the same independent scrutiny and standard as other regulated services. The draft law would also extend regulation to laser clinics, which are already regulated under the Nursing Homes Law, and also hyperbaric oxygen therapy. The Regulation of Care Law was adopted in 2014 following extensive consultation and policy development. It established the Jersey Care Commission as an independent body responsible for regulating care services, ensuring that they are safe, effective, and centred on the needs of those that use them. The 2014 law was adopted with a long-term objective of regulating all Jersey's health and care services. Since its implementation, the law has been extended in phases. The first phase regulated home care, adult daycare and care home services, including children's homes. The second phase extended regulation to children's social care and outpatient mental health services. Each phase has been informed by consultation, evidence, and a commitment to improve standards. This amendment represents the third phase of implementation, and it's a natural progression and one that has been long anticipated. It reflects our ongoing commitment to ensuring that all care services, whether delivered in the community, in residential settings, or in hospitals, are subject to independent oversight. The Assembly approved funding to regulate hospital and ambulance services in the 2023 government plan. This followed a public petition to regulate hospital services, which was launched in late 2021. So far, health services and the Care Commission have had nearly 3 years to prepare for regulation. Let me now turn to the headline changes in the draft law. Part 2 of the draft law makes amendments designed to strengthen the governance and independence of the Jersey Care Commission. Part 3 describes the characteristics of the new services that will be regulated, including hospital and most government-provided health services, including mental health services, ambulance services, and those laser clinic services that are currently regulated under the Nursing Homes Law 1994. That law will be then repealed. And finally, the hyperbaric oxygen therapy services. Part 4 amends the eligibility criteria for members of the board of the Commission, and Part 5 amends the Regulation of Care Standards and Requirements Jersey Regulations 2018. Sir, this legislation matters because it's about protecting people, particularly those who are vulnerable, unwell, or in crisis. Hospital care, mental health services, and ambulance provision are among the most critical services that we offer. They deal with people at their most vulnerable. They must be safe, effective, and compassionate. Independent regulation helps us to ensure that they are. This amendment also brings Jersey into closer alignment with international standards, including those of the OECD and the UK Care Quality Commission. It demonstrates our commitment to transparency, accountability, and continuous improvement. It will also support the health and care workforce by providing clear standards, professional expectations, and a framework for improvement. Regulation is not about punishment, it is about learning, development, and excellence. The development of this amendment law has been informed by public consultation, which took place between April and June last year. The consultation received responses from service users, providers, professionals and members of the public. The feedback was supportive. Respondents recognised the importance of independent regulation and welcomed the extension of the Commission's remit. Some concerns were raised about implementation and capacity, and these have been addressed in the drafting of the law. The Jersey Care Commission itself has been closely involved in the development of this legislation. Health and Care Jersey have also been engaged throughout the process and are preparing for regulation. Sir, I'd like to thank the Regulation of Care sub-panel for their diligent scrutiny of this draft law. The panel made two recommendations to me, both of which I accept. If the draft law is approved, the Government will work with the Care Commission to ensure that all services are fully aware of the timescale for its implementation and how they will be affected by it. I also agree that a clear timetable for introducing regulation of further health and social care services should be produced. I plan to work with the Care Commission and other key stakeholders to develop this timetable and to publish this before the election period starts in April next year. I would then hope that the next government will support this when it takes office later in the year. In conclusion, sir, this proposition is about ensuring that our health and care services are the best they can be. It's not just about protecting people, but also about supporting our professionals and building public confidence. The regulation of care law has already made a significant difference to the quality and safety of care in Jersey. We can see that in the reports published on children's services, which have demonstrated significant improvements since 2023. This amendment will extend that impact to some of our most important health care services. Sir, I propose the principles of the amendment law.
Thank you, Minister. Are the principles of the draft law seconded? Thank you. Does anyone wish to speak on the principles? Deputy Coles.
Thank you, sir. And I rise as the chair of the sub-panel that took the review of these regulations.
Yes.
So I think it's clear that the regulation of care law, since its inception, was always designed to be added to in stages. And so from the briefings and hearings that the sub-panel undertook, it seems that the amending this law at this stage is not only acceptable, but has been very well planned and very well thought through. I think the only outstanding matter that I had from one of our hearings, which I hope the Minister is either able to answer now or maybe as the debate moves on into its next stages, was about the engagement with the local charity offering oxygen therapy. We weren't quite sure whether or not they were operating a hyperbaric chamber or not, but his department was going to investigate back through. But generally, sir, other than that, even regardless of the answer to that question, sir, the panel supports the principles of what the Minister is proposing. But sir, scrutiny side aside now, this is my personal point for this, is that I am pro-regulation, sir, especially when it comes to protecting vulnerable people. So the regulatory work that undertaken by the Care Commission is that which protects vulnerable people. And it's interesting reading from our submissions from the Patient Users and Public Engagement Panel about their comments around psychotherapists. Though currently regulated, the Patients Panel have a strong consensus that regulation must be extended to comprehensively to all areas of health and care provision. But in particular, their members highlighted the need to include psychotherapists, which, like I've said previously, so my view on keeping counsellors regulated in the same manner, I'm glad that the panel supports that idea, because it is something that should come forward. So, sir, it's my continued belief that this is the right form of regulation and that we should all be supporting the principle, sir.
Thank you, Deputy. Deputy Tom Binney.
Sir, I'd like to thank the Minister for bringing forward this proposition. As already explained, the amendment of the law brings hospital care, mental health services and ambulance services under independent regulation. And I think members will agree that it's only right that they're held to the same high standards as other care services that are already regulated. This amendment also brings Jersey closer to international standards, including those used by the UK's Care Quality Commission, and that's good for our reputation, good for recruitment, and it's good for Islanders, sir. I'd also like to address specifically the scrutiny panel's recommendation about the duty of candour. I can tell members that the GMC provided training on confidentiality that included professional duty of candour to a group of senior medical staff during the summer of 25, and a further dedicated session is planned for 26. The Quality and Safety Department have received additional guidance and training to enable them to support the rollout of statutory duty of candour once the law's in place. And further guidance and training will also be made available to all HCJ staff in December of this year. In addition, training programme options are currently being explored to ensure that once the law's in place, staff across HCJ are ready and prepared to meet the regulatory requirement, and we note the timeframe given within the comment paper at the end of June 26. So I'd like to finish by thanking the panel for their recommendation, and I urge members to support the proposition. Thank you, sir.
Thank you, Deputy. Does anyone else to speak on the principles? Yes, Constable St Lawrence.
Thank you, sir. I think this is the right place, right time to raise my question. It's just, I've just got a query about the ambulance service in Part 5. Is this the right time, sir? Or should I be doing that when we actually come to...
I think now is fine.
Oh, sir, thank you. Because the reference here is the provision of an ambulance service as a regulated activity. And then this is Article 32. It refers to the service as being the provision of treatment or care to a relevant patient while that patient is being transported to or from a place of medical treatment, which is fine. That's what I understand the ambulance service to be about. But they also provide care, medical treatment, when they arrive potentially at your home if you've had a fall. If someone's taken ill at home, they turn up, they may be first responders, they're assessing the situation and would be providing treatment in your home, not while you were being transported to the hospital or a place for medical care. So can the Minister just speak to that, please? Where is the care provided in the home covered? Does that come under regulation?
Anyone else want to speak on the principles of this law? I call upon the Minister to reply. Minister.
Thank you, sir. And just running through the people have spoken, I'd start by thanking the chair of the panel. So I've had some really good interactions with the panel, and as I said, I've accepted their recommendations. But he made two points. The first one about the hyperbaric chamber, and I'd just like to say that we are working closely with the people who implement the regulations, implement the work of hyperbaric oxygen therapy, and at this point in time I intend to bring this law forward with that, but continue to work with them before we implement the regulation of their service. We've got more work to do with them. We've identified that, but I'm not going to withdraw that part of the articles just at this particular point, but I will continue to discuss with them before we start regulation. The other thing is about psychotherapy, and as I said in my opening speeches, we will come forward with a timetable. There are other things that need to be done, other services that need to be regulated, and I think that's one of them. We will work with others to provide a timetable of where we're going with that. I thank the Health Minister, sir. He challenged me quite a lot at the start of his term as Health Minister and my term as Environment Minister over this regulation. But I sat down with him, with the team, and he has been assured, to my great satisfaction, that he's very happy with this. He has a difficult task moving from an old hospital to a new hospital, and I was able to assure him with the team that this regulation will be better for both the old and the new. Finally, coming to the Constable of St Lawrence, I'd like to thank her for raising this point, and I can assure her that all activities of ambulance services will be regulated and will be covered by this law, not just the section of the transportation between one place and another, but all parts of it will be covered by that. In summing up, sir, I'd just like to reiterate that this proposition is about ensuring that our services, when it comes to health and care, are the absolute best they can be. This isn't just about public confidence or supporting professionals. This is about protecting people. This amendment will extend that impact of some of our most important healthcare services, and I commend these principles to the Assembly and ask for the appel, sir.
That has been called for. Members are invited to return to their seat. I ask the greffier to open the voting. All members have had the chance to cast their votes. I ask the greffier to close the voting. I can announce that the principle has been adopted unanimously. 46 votes for. Deputy Coles, does your sub-panel wish to scrutinise this matter?
No, sir.
Thank you. Minister, how do you wish to propose the articles in second reading? There are 52 in the schedule.
I'd like to propose them all block, please, sir.
Are the articles seconded? Yes, sir. Does anyone wish to speak in second reading in respect to the articles? Deputy Coles.
Thank you, sir. And I promise members that I won't speak for too long. We have issued our comments paper, and hopefully members have had the chance to read it. Here's one of the shorter scrutiny reports been lodged recently, as I look to my colleague in the Children Education and Home Affairs panel. So the panel held 3 public hearings after initial briefing with the Chair and Chief Inspector of the Care... After the initial briefing, we had a hearing with the Chief Inspector of the Care Commission, along with the Chair of the Care Commission, Minister for the Environment and Minister for Health. I'd like to take the opportunity to thank all officers, both from government and the GREF, for their participation and efforts in supporting us through this short review. The panel heard that the Care Commission were prepared, having already published their single assessment framework back in April. The single assessment framework isn't a simple cut and paste from the CQC's own framework, but it has actually been reviewed and adapted to better fit the Jersey context. We're also pleased to hear that the CQC are actually looking at our adaptations in a way to when they're considering the updates of their own assessment framework. The Care Commission will also be publishing its inspection handbook if these amendments are adopted. It is also important, and the panel has understood that to understand that the regulations proposed here are not designed to be a witch hunt, and inspections are not going to be carried out with the intention to try and catch people out, but rather to encourage improvements across the services as a whole. The panel asked questions around the funding model and if there was a benefit for the service having to pay for their own regulation and inspection. However, it was considered in the Jersey context, this would just be wooden dollars, and it would be, it was opinioned that the funding through the Cabinet Office made things a lot more simple, sir. But it did have to be noted that further funding will have to be provided if the care law is to be expanded any further. It's also important to note that the Care Commission is not here to handle complaints, and that hospital and its service, and that any complaints about the hospital or any of its services should still be made through the government's complaint process. And this is one thing that we would recommend that the Health Minister and all government departments make clear how complaints should be processed and handled. The panel heard from the Health Minister and his team about how their preparations have been ongoing and that they believe they are ready for the inspections to go ahead. There is still to be an agreement between the Care Commission and the Health Department around the number of service managers. However, the panel is not worried that this would be a big issue. We were happy to hear from the health team that there is an attitude of can always be more done, which is good because it encourages things to move forward rather than standing still, because standing still leads to falling behind. On the whole, around the implementation from the Care Commission to health, the panel is satisfied that things are in place and the transitional arrangements and inspection schedules are manageable and achievable. Though the regulation of hospital and ambulance services makes up a large proportion of the amendment law, there are small service providers in the forms of laser clinics, and the changes here represent a move away from the nursing homes law, as the Minister said in his opening speech, into the regulation of care law, meaning that the requirements are more specific to the use of lasers rather than the nursing homes law that they previously sat in. So one of the big key introductions in the new regulation of care law is that of the duty of candour. The duty of candour replaces a legal obligation on services provider to write a letter of apology should there be a serious notable incident which would affect a patient's health. There was concern around this duty of candour being that the letter of apology cannot be used as evidence of liability in legal proceedings. However, the panel is satisfied that the introduction of better rules for the provision of patient care records means that evidence of liability would still be found, but it would be found through the patient records, as there has to be clear reasons for those. The service manager has to provide clear reasons as to why those records should not be provided, otherwise they should be provided with appropriate haste. The consultation, it's clear from our hearing that consultation between the Department of the Environment and the Department for Health and the Care Commission have been very good and have ensured a good understanding. However, it seems that the wider consultation could have been better, as the patients and users public engagement panel were only briefed during the time of this review. So it's always expected that when there is a change or additions to services that are to be regulated, there are questions as to why one thing is being included and another thing is being excluded. It would be overwhelming for any regulator to have to undertake all-encompassing work to do so. However, that doesn't mean that future work and timelines should not be undertaken sooner rather than later. So the panel is very happy with the regulations as proposed.
Thank you. Deputy Minister for Health.
Sir, I'm not sure if this is the right point at which to make this point, but I'd just like to refer to something that was said by Deputy Luce. He's absolutely right. We had some very, very useful conversations at the beginning of the process. I just wanted to make it plain to members that I wasn't fighting against having any regulation at all. My questions and discussions related more to the timing and the process, and whether it was going to be all done in one go, or it was going to be done sequentially. And that's the nature of the discussion we had. I just thought it was important to make that clear to members. Thank you, sir.
Thank you, Minister. Does anyone else wish to speak on the articles in second reading? Minister.
Thank you, sir, and I thank members that have spoken, if only two of them. I can only reiterate my thanks again, sir, to the panel, and I thank Deputy Coles for his speech, because he basically left me very little to say. He's covered many of the points I would have wished to raise, but I do want to talk very briefly, if I may, about the duty candour. Before I do that, I'd just like to thank the Health Minister again. He summed it up well. He challenged me, and he was a critical friend to the proposition that I brought, and we worked together to get to a place where we're both very happy with what's happening here. But I want to talk very briefly about duty of candour, because the duty will require providers to inform service users when something has gone wrong and provide a written apology. They'll have to offer a full and truthful explanation of what occurred and outline any actions taken to prevent reoccurrence. For the first time, sir, health and social care services will be required to admit to care receivers when things have gone wrong, explain what went wrong, and to apologise. And I think this is really important. It's important that apologies are meaningful. That's why we need to ensure that they can be given freely and wholeheartedly without the fear of the apology being used as an admission of liability. An apology given under the duty of candour will not be treated as that admission of liability. So I'm just going to get to the right page. And this mirrors the protections in other jurisdictions and is intended to encourage openness without fear of legal consequences. It's based on the legislation that generally governs apologies in Scotland, and to be clear, far from all safety incidents do arise as the result of negligence. This law is regulatory, it does nothing to affect civil liability and a patient's rights to make a claim against a care provider, and that's important. Excluding apologies from being taken as admission of liability is crucial, in my view, in fostering a culture of transparency and breaking down barriers between the parties when things go wrong. I thought that was important to explain that. I just learned very briefly, sir, to run over a few things about this proposal in the second reading. This legislation strengthens the governance, the accountability and regulatory framework for care services. The key changes include shifting legal responsibility for government-provided care services from individual chief officers to ministers as corporate souls, aligning Jersey with practices in other jurisdictions. These administrative reforms will ease registration for last services like hospitals and children's social work services, allowing multiple managers and premises under one application. In this law, the Care Commission gains power to suspend sole providers, clarify its roles as a regulator and not a complaints body, and offer services to other jurisdictions, provided Jersey's needs remain the priority. Funding reforms will establish a fully grant-funded model for public sector regulation, removing fees for government services and ensuring transparency through strategic planning and budget inclusion. New regulated activities will include hospital and ambulance services, laser clinic, and eventually hyperbaric oxygen therapy, reflecting risk-based regulation. The definitions will ensure clarity and exclude services like outpatients-only clinics and prison healthcare. Commission governance is modernised. Commissioners may serve up to 9 years. Eligibility criteria are relaxed to allow broader expertise, and staff employed via the states are formally recognised while retaining regulatory independence. Regulatory standards are updated to improve transparency and service user rights. A new duty of candour, as I said, requires providers to admit when things go wrong, apologise and explain. Services must support visitor access, communicate effectively and allow access to care records where appropriate. Further provisions ensure vehicles are fit for purpose, registration is publicly visible, and significant restrictions on liberty are reported. Inspection frequencies are clarified and a temporary defence is introduced for hospital premises not yet fit for purpose, providing mitigation steps are taken. Sir, these reforms aim to enhance safety, enhance accountability, and improve public confidence in Jersey's care system, and I ask for the appel in the second reading.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. Four members with the opportunity of casting their votes. I ask the greffier to close the voting. I can announce that the article's been adopted unanimously in second reading, 46 votes for. Minister, do you propose the matter in third reading?
I do, sir. I have nothing to add other than my thanks to the Assembly for their wholehearted support. I'd just like to give a very short vote of thanks to various people, if I may, sir, at this point in time. I'd like to start by thanking yet again the Regulation of Care sub-panel for their work and the way that they worked with me to get this over the line. I'd like to thank the Jersey Care Commission, the Health and Care Jersey officers, the Health Minister and the Minister for Social Services, the Minister for Education and Lifelong Learning for their work in cooperating and bringing this forward. Finally, sir, I'd just like to thank the Law Drafting Office and the Law Officers Department. This has been a considerable piece of work over a very long period of time. Lots of time and effort has gone in, and I'm very grateful for their effort.
Thank you, Minister. Is the matter seconded in third reading? Yes, sir. Does anyone wish to speak on the articles as adopted in third reading? Is the appel called for?
I call for the appel, sir.
Appel has been called for. Members are invited to return to their seats, and the greffier is asked to open the voting. All members with the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the draft law has been adopted unanimously in third reading, 46 votes for.
Sir, could I propose the adjournment?
Members content to adjourn now? Assembly is adjourned until 9:30 tomorrow morning.